From a man facing disturbing charges of sexual exploitation,
the state has failed to elicit any testimony showing the probability that the coercion of child sexually abusive activity was for the purpose of producing any child sexually abusive material.
To another caught illegally carrying a firearm in his vehicle.
Were you in a motor vehicle?
Yes.
All right. Did you have a weapon in your possession?
Yes.
All right. Do you have authority? And it was in that vehicle?
Yes.
Where was it in the vehicle?
My possession.
These cases show how Judge Simpson ensures offenders are held accountable with no excuses. Starting with Mr. Radcliffe, who is facing charges tied to child sexual exploitation, coercion, and abuse of power, from grooming his victims to manipulating them. Let's see how the judge handles this.
Does call the case of the People's State of Michigan versus Zachary Radcliffe. Counsel, appearances, please.
Good afternoon, Your Honor. Amy Rise on behalf of the people.
James Thomas on behalf of Mr. Radcliffe.
I didn't know Johnny on behalf of Mr. Radcliffe.
Where we left off at the last hearing, counsel was making argument regarding the absentee exam and the legal inability of the court, if that were the case, to find a defendant over. And I asked for regarding that issue. I received a brief from you. I don't think that I'm sure the brief did not address the issue that was raised for the court. It addressed something else, unless I am mistaken. Yeah.
Your Honor, the court asked for us to present a brief that addresses the question of whether or not material was necessary. Child sexually illicit material was necessary. That's the brief that we submitted to the court on an argument of statutory interpretation and the category of criminal liability that the theory of the prosecution presented in testimony. I'm happy to go through that argument if that helps the court clarify.
You would need to, because as I read the brief, it doesn't address the issue that you brought forth to the court. I would also indicate, and I'll let you go ahead, but I would also indicate, I think it's a footnote 2 of your brief, that's a bit disingenuous if the court did not permit you time to go through a transcript. I get a little bit sick and tired of that, because the court has tried to provide everybody an opportunity to bring whatever issues it can before the court. And for you to say that the court did not provide you opportunity to go through a transcript, not in terms of a transcript, because one was not prepared, nor did you demand one. In fact, so that the record's clear, you requested of my staff a video of the proceeding. Requested that on Tuesday, the 25th. That video was expedited by my staff and given to defense counsel on Wednesday morning. So all of that really should have been put in there so that that's not an issue in the future. I think that that is more than adequate time to prepare the issue before the court. You may go ahead with your argument.
Thank you, Your Honor. Your Honor, for the record, I would like the record to reflect that we did not receive the state's response till after 5 o'clock on Monday, as the court directed that we should have received it before 5. Regardless, Your Honor, I would like to...
That caused you any prejudice?
I'm just placing it on the record.
No, but has it caused you any prejudice?
In a sense, Your Honor, it had, because if we received it before 5 p.m., then that would have given us more time to evaluate the state's position. But we understand and we...
Position, counsel. Another disingenuous argument. Go ahead.
Your Honor, the state conceded in their response that Mr. Radcliffe falls within the first category of criminal liability under the statute and under People versus Atkins. That category is a person who persuades, induces, entices, coerces, causes, or knowingly allows a child to engage in child sexually abusive activity for the purpose of producing any child sexually abusive material. The state's theory is that Mr. Radcliffe did this by encouraging the alleged victims to make masturbation videos and email them to a Yahoo email or upload them to a Snapchat account provided to Trooper Ryan by the alleged victims. Your Honor, under People versus Willis, the Supreme Court in their order 1574652 stated, only as it pertains to this group, the first group, as I indicated earlier, must a person act for the purpose of producing any child sexually abusive material in order to violate the statute MCL 750.145C2. The state has failed to elicit any testimony showing the probability that the coercion of child sexually abusive activity was for the purpose of producing any child sexually abusive material. as child sexually abusive materials defined as a developed or undeveloped photograph, film, slide, electronic visual image, computer disc, or sound recording of a child engaging in the list of sexual acts. We agree that the act that's elicited here or that the state concedes is masturbation as well. The state conceded that no evidence of child sexually abusive material was testified to and relies on evidence still being processed. This court cannot consider evidence that has not been presented. Evidence that it's at a crime lab still being evaluated is not evidence that was presented at the preliminary exam. The state also relies on two cases, People versus the state relies on People versus Sturza. They indicate in those cases that the court affirmed the conviction. Your Honor, in that case, the defendant didn't fall under the first category. The theory of guilt presented by the state was that the defendant fell into the second category or even the broader third category. Your Honor, in addition to that, when we look at the jury instructions for child sexually abusive activity causing or allowing, that requires some form of material. As I presented that definition to the court, that element is needed under that jury instruction that the child abusive material be a picture, movie, or illustration made or produced by any means. No evidence of that form of material was presented in this court during the preliminary exam. Probable cause requires a quantum of evidence sufficient.
It's not true, is it? You have the testimony of these 9 witnesses, or at least 7 of them.
That is correct, Your Honor. But in the end of those, none of the testimony referred to actual material as is defined under the statute. Material requires a photo. It requires an image of some form, a video, whether developed or underdeveloped. It could have simply been undeveloped negatives of images. Nothing of that line was presented during testimony. Trooper Ryan testified that he reviewed a camcorder and 7 videos that came with it. None of them contained any material that was child sexually abusive material or child sexually abusive activity. He testified that his first Snapchat warrant came back and had nothing that supported that form of material. He testified that Google came back and found nothing from the witness Weston's Google email address that supported child sexually abusive material. He also testified that Yahoo came back in relation to the Yahoo email address that was provided to Trooper Ryan from one of the alleged victims, that nothing came back from that address. Nothing was testified to during preliminary exam that meets the definition of child sexually illicit material. And given the fact that the state has conceded.
The witness says, I produced this movie, and this movie falls within the definition of the prohibited materials. You're saying that's not enough.
Your Honor, that is correct.
That's the case I was looking for. So, and where I don't have one.
So, Your Honor, the Supreme Court indicated in their order in Willis that that's a question that's being presented here. Here, we're asking this court to look at statutory interpretation. When we look at statutory interpretation, we first look at the plain language of the statute, whether it's ambiguous or not. In Atkins, the court looked at that statutory interpretation, determined that because of the first form of criminal liability does not have an or between child sexually abusive activity or child sexually abusive material, it requires the form of material. If the state had made any other argument, then we would have a different conversation. Here, the state's theory in this case is that Mr. Radcliffe coerced, encouraged, gave an idea to these alleged victims. That falls under the first prong, the first form of criminal liability. Therefore, the state has to produce a form of material. That prong is to protect the community from production of child pornography. If their argument that is what he did here, the law requires them to present a form of material. The court may ask for a case on point, Your Honor, but we know how cases on point are created. They're created by these forms of challenges. So that is why we're bringing this challenge before the court to evaluate this case, listen to the state's argument that they are placing Mr. Radcliffe into the first category of criminal liability. The state has lifted that. They indicated that in their response. They conceded to it. So therefore, they are required to present some form of child sexually illicit material to fulfill that criminal liability portion under that first category. For those reasons, Your Honor, we ask this court to deny bind over on the charges that are associated with child sexually illicit activity, charges that are associated with aggravated child sexually abusive activity, as well as charges associated with using a computer or internet to commit those crimes. We also request this court to deny bind over on the other counts, count 1, count 5, and count 33 of this case, as discussed in our last day of preliminary exams.
Response.
I listened to counsel state that the statute requires some form of material. The state has to present a form of material. They are required to produce some material. What counsel is asking, Your Honor, to do is to rewrite the legislature and add an element to the crime that doesn't exist. They keep citing to the order in Willis, and it's an order. The defendant's application for leave to appeal for his conviction for child sexually abusive activity was denied by the Supreme Court. The court goes on to provide a synopsis of the child sexually abusive activity and the definitions therein, and indicate that the defendant has nonetheless raised pertinent concerns regarding the breadth of the statute that may warrant further review by the legislature. So I don't think I need to tell counsel that this is not the legislature. This is a court. The standard before the court is whether there's probable cause that a crime was committed and this defendant committed it. And that's the standard here today. To write something in a pleading to Your Honor that she didn't have time to obtain a transcript, or somehow she's unfairly disadvantaged. There's nothing in that transcript that would indicate that we have to produce child sexually abusive material. The statute is clear, and we're not conceding. I didn't concede that there was no evidence of CSAM. Every single one of those victims testified to the coercion, the request, the sort of grooming of the defendant in obtaining this CSAM from them. He gave them the address. He told them how to do it. He critiqued the videos. So there are no physical videos at this time, but there was evidence about those videos. They all uploaded it to the address he gave, to the Snapchat he gave. So I'm not conceding anything. There is no requirement. Counsel argued before Your Honor on Tuesday, the 25th, that there had to be a video. Your Honor gave her a break to go get that case law, and then an adjournment until Friday. The case law doesn't exist. There's no requirement. This is a probable cause standing. All of these victims came before Your Honor and testified to the grooming that happened by this defendant. He coerced them into making them feel like this was a normal thing for a 15-year-old boy to masturbate on a video and send it to their mentor at the church. He made it seem normal. He coerced. He allowed them to do it, and they were all under the age of 18. The fact that my response to her, whatever that was she filed on Friday, because it wasn't any case law to support her point, arrived at 5:06 p.m. She claims she's disadvantaged. And this is really, really unbelievable. And so I would just ask, Your Honor, the evidence for all of the counts, for each of those victims, they engaged in child sexually abusive activity by masturbating naked in front of a phone, their cell phone, and they did that at the request and coercion of this defendant, and then they sent it to him on Snapchat, on email. And so there's no requirement that those videos be recovered. That can be an issue for the trier of fact. She can argue that all day long in front of the jury. She can make that argument to them, that there's no video, so this didn't happen. And that's going to be for the jury to decide. And so we would ask that you bind over on all of the child sexually abusive activity counts. There's one for each victim. And so I suggest to this court that this case law suggests that for each victim, I could charge one for each video they made. So there could be multiple counts for each victim. And the CSC 1 charges with the victim Cole and with the victim Jacob. The testimony was very clear before this court that the defendant held a position of authority in the church. That's how he met both of these victims. And again, it is our position that he groomed them. And Cole was under 13. and I'm saying his name Cole. I believe that his name was Christopher in the record.
Yes.
Christopher testified that he was under the age of 13 when multiple penetrations occurred. He turned 13, and total in all, he's estimated 15 penetrations under the age of 16 at the defendant's residence when he met him at the church, when he was in a position of authority over him at the church. So there is definitely probable cause that those 6 counts of criminal sexual conduct in the first degree were committed, and that this defendant committed those. As well with Jacob, he testified to...
If I may stop you just for one moment. On the issue regarding Cole or Christopher, there are 6 counts. Are the 12, 13, 14, are those in the alternative to 15, 16, 17, or in addition to?
No, Your Honor. The 3 counts of CSC with a person under the age of 13, those are the penetrations that occurred when Cole was 12 years old.
Gotcha.
There's no showing that I need to make that he was in a position of authority, just that he was over the age of 17 and that the victim was under the age of 13. And those 3 charges carry a mandatory minimum 25-year sentence if the defendant is convicted. The additional 3 counts, the penetrations for Cole, would occur when he's 13, 14, or 15, and the defendant is in a position of authority at the church. So although Cole testified to 15 penetrations, I have charged only 6 of those. 3 when he was under 13, and 3 when he was between the ages of 13, 14, and 15, and the defendant was in a position of authority.
The reason that the court is asking is, like you said, with the individual events on the CSAM and aggravated CSAM, if the testimony were to reveal the people, and those the court heard the proof, believes the proof, could add counts.
Yes, absolutely.
Yes. And so, and part of my reason for asking, because I'm still trying to make a determination of this, if those are pled in the alternative, that would be a potential of really 24 counts, but 12 that he could be convicted of. If not pled in the alternative, then given the testimony, there could be an additional 9 counts. My math being that starting with the 15, 3 specific to 13, but there always is this relationship issue.
Correct. So I do believe, certainly for probable cause level, that there is sufficient evidence to bind over on the penetrations for the victim identified as Christopher, that I'm now calling Cole. Additionally, the CSC counts for the victim identified as Jake or Jacob. He testified to 2 very distinct penetrations. One occurred when the defendant, of course, was in this position of authority, had access to that victim at the church when he was 13, 14, or 15. The first penetration occurred in the vehicle outside the victim's home. And the second penetration occurred the following summer in the defendant's vehicle in the church parking lot, both located within Washtenaw County. And I believe that there is sufficient evidence that he was in a position of authority. That's how he had access to Jacob. He still continued to see him at the church. And again, in line with the defendant's sort of grooming of all of these young men, friended him on Snapchat, knew he sort of was in a vulnerable position with his parents, and the victim snuck out of the house for the defendant to sexually assault him, not once, but twice. And so we would ask that you bind over on both of those counts of criminal sexual conduct in the first degree. And his age, he testified to, was under the age of 16 at the time that both of those occurred. And for the reasons previously argued, and the testimony and the lack of support from defendant's argument about there needing to be a video, that just isn't a requirement of the statute. There's certainly evidence in this case, and I won't reiterate and read all of the charges again, but there is evidence that the defendant persuaded, coerced, enticed these young men to engage in child sexually abusive activity. And in fact, they did. And it was for the purpose of producing this video, which they also testified they did and sent to him. He also paid them for it. He really fits in all three categories because he financed this. He paid them money. He bought them items. So we would ask that you bind the matter over to circuit court on all of the counts contained within the felony information, with the exception of count 1 for Holly Jordan, count 5, and count 33. We did not hear testimony on those counts, and so we would not be moving or bind over on 1, 5, and count 33.
In response to the state's position, you heard the state indicate coercion again, indicating that their argument is that Mr. Radcliffe coerced these individuals into making the videos. The defense is not trying to rewrite.
Counsel, under the statute, would that matter?
It does, Your Honor. Under the statute, coercion falls under the first criminal liability under Adkins. That is case law. It is case law presented by the Court of Appeals that divides criminal liability under the statute into 3 categories. First, being the coercion piece, persuasion. That category is what they have put Mr. Radcliffe in, and that category requires the form of material or for the purpose of producing material as defined. So, Your Honor, we're not trying to rewrite law here. We're trying to refresh the court's memory on the fact that interpretation of the law has been made here. Adkins created 3 criminal liability categories. The state chose their theory of guilt. They chose how to ask their questions. They presented that evidence and presented a theory of guilt based on coercion. They placed themselves in the first category under Adkins.
So that,
if I may, Your Honor.
It certainly can be addressed in terms of coercion, but go ahead.
In addition to that, Your Honor, Mr. Willis didn't fall under the first category. The defendant in that case fell into the second category. There was proofs presented that dealt with arrangement or attempting to make arrangements. In addition, the same goes with the case that they relied to, Sturza. In that case, category 2, maybe even category 3, broader. In that case, there was arrangements. There was testimony that was pulled that dealt with that information. Here, the state didn't have that theory of guilt. They didn't present that testimony. And now at the end of oral argument, they're saying, well, he could be under every category. Your Honor, the state chose their theory of guilt. They presented their theory of guilt, and that was coercion. That was encouragement. That was the allegations that Mr. Radcliffe told them about this as an idea, right? That's what led to the actions. The state also says in their response that Mr. Radcliffe requested. He didn't request this information. There was no testimony of that. Many of the victims indicated that he suggested the idea. They did nothing because they felt it was awkward or inappropriate, but later chose to reach out to him and ask if they was still an option. That's not a request that was testified to. That was an idea that was presented and a victim choosing.
An idea presented to a 13-year-old.
And that would fall under the coercion encouragement. Your Honor, the court defines encouragement as if I may, defines encouragement as to attempt to persuade or to spur on. And they do that in Sturza, the case that the state is relying on. So if that is encouragement, that's the idea that was presented. That places Mr. Radcliffe in the first category by the actions of the state. Therefore, the state has to meet that burden of presenting material here.
You're making that up about material. Again, give me a case that says that. I'm not here, hold counsel. I'm not here for some educational experience of statutory interpretation. I'm not here to do that. We have the law that we have. Now, you may not like it. There are plenty of laws that I have to enforce. I may not like, but I can't go just making up new law. That's not my job as a judge.
Your Honor, the law is the statute. Am I correct on that presumption?
I don't answer your questions.
Your Honor, the law here is the statute that the state is relying on. The statute has been broken down in Atkins case law presented to this court in those 3 categories. That's case law, Your Honor, that we are presenting to this court. Unless the court can find.
None of that says they have to have the material.
Your Honor, Atkins indicates the 3 categories. The case of Willis uses those 3 categories to define the requirement for material.
You keep saying it doesn't make it true.
Your Honor, that's what the case law says, that Willis
You keep saying it, don't make it true, counsel. You can say it over and over and over and over, and it doesn't make it true. I've asked you for it. Ms. Reiser points out, gave a break, present it to me, gave time, present it to me, not there.
Your Honor, am I understanding the court to indicate that the case of Willis does not present that there are three categories?
I think I'm very clear in what I'm telling you. Now, how you interpret that and try to twist it, that's your business.
Your Honor,
I think I'm real clear in what I'm saying, because I don't think anybody has said I'm not clear. When I say
Your Honor, our position is that the state has presented a theory of guilt based on coercion, which puts Mr. Radcliffe in the first category under Atkins, and under Willis requires some form of material. That is our position as the defense.
Anything else from the people? Mr. Reiser?
No, Your Honor, thank you.
All right. Court's going to take likely exactly 10 minutes. I will come back with my decision argument. Court stands in recess.
This case reveals just how far someone can go to manipulate and destroy young lives. Judge Simpson is not letting this slide easily.
Back on the record in the case of the people of the state of Michigan versus Zachary Radcliffe, counsel is all present, as well as the defendant. The court, in attempting to try to make a determination of bind over in these cases, and the court will not, of course, bind over on counts 1, 5, and 33 as the complaint now stands, given that there was no testimony, so we can get that out of the way. But let me just say at the beginning, this is a probable cause hearing. This is not the trial. I've given, certainly in this court's mind, every opportunity for counsel to present whatever they wish before this court for this court to consider. Some say maybe bending over backwards to make sure that all of the information gets to me. But one of the things that I said at the end of the last proceeding when I adjourned for the filing of briefs, and there was a loud exclamation coming from that side of the courtroom because it was being adjourned, and I did not take offense at that. But one of the things that I stated is that my job is to do the best that I can to get it right. And I was going to take and do whatever I could to make sure that I got it right. I owe that to the alleged victims in this case. I owe that to Mr. Radcliffe. Sometimes, as I stated, that we often or sometimes can end up in situations where the law says something. We may not like that law. We may not like the way that it is laid out. But I'm not here to create new law. I take the law as it's written by the legislature, take the interpretation either that higher courts are given to the law and otherwise. There is nothing that this court sees that requires that physical piece of evidence. Now, counsel may argue that at trial, might be a good argument at trial, might be a successful argument at trial. But at this stage, that's not what it is. I listened very closely to the testimony of 9 young men about their version or their view of what they had been through. And let me just say, so that it is very clear on the record, that as I listened to each one of them, not only is their testimony before this court compelling, I found their testimony exceedingly credible. Each one, in their own way, at various times as they were testifying, were recounting things that, quite frankly, for them, was extremely painful. And you could see it on their faces, you could hear it in their voices. And to a man, when asked a question where they maybe could have made something up, they said they didn't know. They weren't trying to mislead anybody in this court's mind. They wanted to be heard. And they said what they had to say. And like I said, for some of the witnesses, at great pain to them to try to recount it. But I will say this also about them. And while I say that their testimony was compelling and extremely credible, every one of them was courageous. I don't know that there are many people that, having gone through what they testified, would be able to stand before any court or any place and say those things. With some of them, it was very hard at times. I will be free to admit it. Watching as they're relating what had transpired and at the same time seeing in their eyes and watching their expressions as to various degrees they begin to dissociate from what they're telling, because that's probably how they've had to live their life and sort of separate out this whole series and times from who they are now and progressing. But one other thing that I noticed about all these young men, to a person, they were almost saying that it was over in a way, because every one of them, I watch very carefully. People don't think I see things, but I see everything in this courtroom. As they're telling their story, they're looking the defendant right in the eyes. They're not backing down. They came here to say something. As Weston said, that you kind of go and you just get the job done. And he was, particularly Weston, you could tell it was very hard for him. I think it was hard for all of them, but it was hard, particularly for him, to go through that. I wanted to make that very clear on the record in terms of this court's perception of all of the victims as they testified, because I think that's important. It's important, and I'm not going to be the final decision maker on this case. That will likely rest with some jury. But what I saw with them, they need to be believed, and they ought to be believed. Whether anyone does, that's maybe for the future. But I believe them. I believe everything they told this court. Having said that about the victims, I also now turn, because I think it's important to understand at least the court's view of the context of this case. I don't say this lightly at all. Not how I operate my life, and certainly not how I operate as a judge. But in my 25 some plus years, I've seen a lot. This ranks up with one of the most egregious predators that I have ever seen as it regards individuals. As you listen to each one of these young men tell their story, and I don't think the prosecutor, though you could hear the emotion in what she was saying, I don't know that grooming really defines it. But it is a grooming. It is just this molding of these individuals to sort of succumb to his will. And counsel talks about the issue of coercion. Coercion can happen in a lot of different ways. Sometimes it can happen directly, sometimes it can happen indirectly. These young men in this court's mind were coerced. But it's not going to be you do this or else. That's the most direct form of coercion. This coercion was more insidious, and I put this idea in your mind. Then I come back to it. And almost that circumstance where, as defense argues, but I don't agree, that it almost becomes these victims' idea. One always has to remember, however, and I don't like using this, but I allowed it to be said in the courtroom because I don't allow disrespectful things to be said about people or groups of people. Remember, to entice some of these victims, the defendant perpetrated a story to them of the Japs. And I don't like saying that, but when I first heard it, I thought I had been dumped into a 1940s World War II. But many of them kept saying that that's what he said to them. So that it wasn't him getting this and giving the money. It was some other people doing this. Fair to say, I don't believe, when I listened to everything and analyzed this case in my mind, that those people that he said existed ever did exist. Regrettably, I think that there wasn't anyone financing this, as exemplified by what Isaiah was given and what Ian testified to, that it was a church that paid for it. Sad to say, but I think that's what happened. That iPad, those headphones, so that one can recall, Isaiah testified about that, and then it was Ian, who worked at the Apple store, that provided the information that was paid for by the church's credit card. So that racially derogatory term that the defendant was using with these young boys, those folks didn't exist at all, I don't think, in this case. But part of his grooming, he was incredibly and remarkably consistent with these individuals. There was the money. not just the money that was paid for the videos, but there was just money given to these young people. There was clothing given to them. There were trips to the mall. All of these things that anybody that has ever been around teenagers know are enticements to them. And all of these things are done. And one of the things that also is a bit remarkable is that he would take them to the movies. No allegation that anything necessarily occurred there, but I have my suspicions as to why he chose that particular theater as opposed to another one. There are two others around here that certainly they could have gone to. The coercion that's created, the sort of false image, this sort of grooming, and all of this mixture of stuff, based on the testimony before this court, this defendant perpetrated these acts against these children at the time under the auspices of the church, under his auspices and as a mentor to them, as almost family to them, as somebody that was supposed to be teaching them. He used all of that to manipulate these young boys in this court's mind to do something that they would not ordinarily have done. With reference to the specific counts, I'm going to lay them out this way with sort of go by victim so that we can try to keep this clear. With regard to Isaiah, referencing counts 8, 23, and 24, his testimony, indeed, this court found credible, reveals that the people have sustained their burden of showing sufficient evidence to find a defendant over to stand trial on those counts, 8, 23, and 24. There is additional testimony that there were, as the people have suggested, other videos not charged. But this court has the authority to add charges where this court believes that the evidence suffices to add charges. So while I will sum it up momentarily, the court is adding 3 to the specific allegations regarding Isaiah. The court is adding 3 counts of CSAM to the charges. With reference to Noah, in regard to Noah's testimony, going through and the court having found his testimony credible, with regard to what was done and how this individual, Noah, was called upon to make these videos and send them off to specific locations which the defendant had given to him, and that with all of these individuals, he induced, enticed, otherwise encouraged the production of these things. That's clear. I'm finding that regarding all of these. But specifically regarding Noah, that being counts 9, 25, and 26, court finds that the people have indeed sustained their burden with regard to the charges listed in the complaint. Court is adding 3 counts of CSAM to the allegations regarding Noah. Regarding Maxwell, the testimony of Maxwell also clearly indicates that he would take them to movies, football, watching the football game, going to the Imagine Theater, and that he encouraged and enticed Maxwell to engage in these acts to then send the videos off to him, and that particularly regarding him and others who would receive payment for these videos. In that respect, there were 20 to 30 videos that were testified to as the number of times. The court, in attempting to be judicious, but realistically at least 20 should be added, but the court will add 3 additional counts. So the court, make that clear, the court would find that the people have sustained their burden as to counts 10, 27, 28, and there will be 3 additional counts as it regards Maxwell. For the time, I'm going to skip Cole or Christopher and Cole and get to Jacob. It is not contested as it regards Jacob that not contested, nor was it argued on bind over regarding the testimony of Jacob, which the court found very compelling. The court would bind the defendant over to stand trial on counts 29 and 30, the people having sustained their burden. With regard to Weston, again, his testimony for the court was very similar to the others in that he would testify that he was like a brother to me, that they communicated through Snapchat, and that he was going to make money for the masturbation videos. Also, that he would be taken to the movies and the like. It's also interesting with regard to that he gave the same email address where certain of these victims gave them the same type of instruction. Testified that there were 15 to 20 videos that it would be $80 to $100. He would get more, between 200 250 if he showed his face. And it's consistent with the other victims in this case that there would have to be the high-pitched, almost female moaning that would have to take place. So with regard to Weston, as regard to the charges contained in count 3, 4, and 6, the court does find that the people have indeed sustained their burden. As to those counts, the court would add 3 additional counts of CSAM as it regards Weston. With regard to Ian, and again, Ian's testimony was the same, but a little bit different in certain respects, because Ian was the one that broke the notion of what happened to the iPad and the headphones, and knowing that they were paid for out of the, or by the church card. His arrangement was, I won't say somewhat different. It was these were all sort of cash transactions, and some cash going one way, some cash going another way. But in listening to that, he specifically testified that he would, if he sent the videos, and this is where Ian's gets a little bit different, he would send the videos, he would get a discount for basically studio time or production time. And specifically testified that if there was this bro job, that the $1,500 would be as forgiven or paid for. It was a bit hard to listen that he was actually paying $1,000 to someone, and then this person was doing this to them. It just incredible in my mind that he would do that. But he testified that there were 20 to 30 videos that were sent, also given specific instructions as to what to do. Court would find as to Ian that the people, with regard to counts 18, 19, and 20, people have indeed sustained their burden, probable cause, and the court would find the defendant over on those 3 charges, along with 3 additional charges of CSAM specifically related to Ian, him testifying that there were 20 to 30 videos. There was then Reese, and Reese specifically had testified about the Snapchat 2014, and that he had been there. He was very specific in terms of this particularly time frame, that this was a bit different than the others because he was supposed to get paid but never did get paid. He was a lot like, I believe it was Maxwell, who really never saw any money. The defendant was holding his money. It just incredible, because that was the trust that he had engendered to these individuals, and broke that trust. One never knows whether it was ever intended upon paying these individuals. But after listening to the credible testimony of Reese, the court would find that as to those 2 counts, 31 and 32, that the people have indeed sustained their burden. With reference to those counts, the court would indicate that Reese testified that there were 30 to 40 videos. The court would add an additional 3 counts as it regards CSAM, as it regards Reese. As it regards Devin testified. This Devin is particularly related to counts 7, 21, and 22. That he looked at the defendant as an older brother, brother figure. Many of these individuals sort of manipulated at times into believing that this is what young men do, and so therefore, and what brothers do regarding that. His enticement at times to some of these individuals was sending the video himself, knowing that it had to be returned or should be returned because he created this image of this happy come day. Specifically with regard to Devin was asking for pictures with face and other things. But it's really the same behavior and manipulation that is just prevalent through all of these victims. Testified that there were 30 to 50 videos that transpired. So with regard to Devin, the court would find that the people have indeed sustained their burden as it regards count 7, 21, 22, and would bind the defendant over on those charges, and would also bind the defendant over on an additional 3 charges of CSAM. Going back to, and so that the record is also clear, given the number of videos testified to, the court would also bind the defendant over on count 2 and count 11, that the court would find that the people, based upon the testimony of the victims, have sustained their burden of showing that those offenses, those charges were committed, this defendant committed those offenses. Going back to Christopher and or Cole, also known as Cole, there are 3 counts of CSE first degree and under the age of 13. With specific reference to Christopher's testimony in the case, and it was, again, a circumstance where he would buy for Christopher clothes, shoes, all part of a grooming process, all part of that. But Cole, Christopher, had another issue, which isn't uncommon for teenagers, but one thing that he was testifying to was problems that he was having with his mother, and that this defendant, according to his testimony, was there for him. And so having problems at home, that he would go with this defendant. He also then entered into this game with Christopher about these bets about eating food, and then would have to enter into an oral sex act of sucking his penis, and then he had to uphold his bet. This, again, that manipulation of these individuals. Upon direct examination, when asked how many times these oral sex activities occurred, Christopher was very specific. He said 15 times that occurred. Whenever he tried to, I guess, pull away in some way or not do something, he was very specific that the defendant would cry and say he's breaking his heart and those kinds of things. Obviously, sort of trying to play to Christopher's good nature, that Christopher would then just give in so that this other person, no matter how much pain I guess Christopher was in, wouldn't be in pain. And then specifically asked, after examination, I specifically asked Christopher, again, how many times? And he repeated specifically to the court at the court's questioning that it was 15 times. I believe him. I believe that he was put into sort of, for him, for Christopher or Cole, an impossible position, and that it occurred 15 times to him. So as it regards the counts 12, 13, 14, 15, 16, 17, those 6 counts, the people have sustained their burden, showing that the defendant, that these offenses were committed and that the defendant committed these offenses. And so the court would bind the defendant over on those charges. Additionally, the court is adding nine counts of CSC in the first degree regarding relationship, those specifically related to Cole and specifically related to his testimony, so that the record is clear. All counts with the except that are listed on the initial complaint, with the exception of 1, 5, and 33, the defendant is bound over to stand trial on. With reference to the particular 7 individuals, those would be those that testified, excluding Jacob and Christopher. There will be 21 counts of CSAM added to the complaint, and then 9 counts of CSC in the first degree relationship specifically related to Christopher Cole also added to the complaint. So as I have it, counsel, there would be a total of, we started, I guess, with 33. There are 3 that are not bound over. The defendant will be bound over to stand trial on those 60 charges.
Now have a new information prepared prior to the first pretrial in circuit court. As a housekeeping matter,
Are you going to talk about the numbering?
I am talk about the numbers, or should I just?
Well, what's going to end up happening, our system, the numbers ended, and we went through this before, the numbers ended at 33, right? Oh, they're not going to add them here. Okay, let me put it this way.
So should I?
As to the numbering that the circuit court will take the filing on, I can't get into that. What I will say is that my care or register of actions will indicate successive numbers as I've laid them out during this discussion, starting at 33. So starting with 34.
So 34.
34 all the way up.
Got it.
So it will really end up with 63, but 3 are not bound over on. Unless I hear anything further from either side, defendant's bond will continue as denied. Thank you.
Now we have Sandra Scott, already facing serious trouble, now caught up in a firearm possession case. Instead of staying out of trouble, he chose to flee from police, leading to a chaotic chase and an even bigger legal mess. Let's see how that works out for him.
Yeah, let's do it. Court does call the case of the People State of Michigan versus Sandra Scott.
Sandra, on behalf of the people.
Scott.
Assistant Hogan, that Mr. Scott who is approaching. United States daytime separate preliminary examination. The people are prepared to proceed. I will put on the record that I had conveyed an offer prior to the examination that if the defendant were to waive as charged, the people would offer a plea to count 1 and dismiss 2 and 3, as well as not file a habitual 4th. In this case, it's my understanding the defendant does not wish to avail himself of that offer.
Is that a correct statement, counsel?
It is correct, Your Honor.
All right, very good.
The people expect to call 3 YPD officers. I'm going to have Officer Plimalas come up first, and I'll have the other 2 officers excuse themselves, which will be Officer Lundy and Officer Cheese.
Okay, very good. Sir, please come forward and be sworn.
Please take a seat, raise your right hand. Do you solemnly swear to tell the testimony about the truth and all truth and nothing but the truth, so help you God?
Yes, sir.
Have a seat. State and spell your first and last name for the record, please.
First name is Zachary, spelled Zachary. Last name is Plymel, spelled Plymal.
All right, you may inquire.
Thank you. Officer Plymel, how are you currently employed?
Currently a police officer for the city.
How long have you worked for the City of Ypsilanti Police Department? Thank you. Were you working as an officer with the City of Ypsilanti back on January the 23rd of this year, 2025? And were you dispatched in the vicinity of the Ypsilanti Transit Center on Pearl Street in the City of Ypsilanti?
Yes, sir.
What was the nature of that dispatch? And do you know who had made that complaint?
One of the security guards at the transit center. I'm not sure of the name.
Okay. And based on that information, what did you do?
The security guards informed us that.
Objection, hearsay.
Your Honor, people are not offering this for the truth of the matter asserted, but only to explain what actions this officer took.
Your response to that?
I don't think it's responsive to the question, and I would also say that if it's not offered for the
It's
truth.
being offered for the state of mind, in essence, as to why he did what he did. Objections overruled.
Thank you.
Security guards were complaining of a disorderly person in the transit center refusing to leave. And when he finally did leave, there was a handgun in his waistband, which is why they called the police. After they showed us a picture of the person that they believed had a handgun, and they stated that he was going southbound on Washington, so he spread out, and that's why we left the transit center.
You're using the term "we."
Me, Officer Plymel, Officer Lundy was on scene, and our Sergeant Schrammick were on scene at this time.
Okay. You received this information from the security guard at the transit center. They indicated this individual had proceeded, I think you said southbound. Okay. And where did you go then?
We split up, and I went southbound on Washington Street with my patrol car.
Okay. And you had seen a photograph of the individual that was, I guess, the suspect or the person of interest?
Yes, sir.
Okay. Thank you. You headed southbound in Washington. What, if anything, did you observe?
I observed, a subject walking northbound on Washington Street that matched the description of the person in the photo.
And what did you do?
I put my car in park and I called on the radio, ordered my location, and then I was going to be making contact with the subject, or he took off on foot through the alley.
So he took off on foot? Prior to him taking off on foot, had you got out of your car or yelled, "Stop, police," or done anything at all?
No, sir, he was already running before I even got out there.
Okay, so you're southbound on Washington. What direction of travel is he now heading?
Heading westbound through the alleyway there.
Through the alleyway? Okay. And Washington and approximately cross street, what are we?
Michigan.
Michigan?
Just,
The observations that you made that this individual was heading into the alleyway, what did you do with that information?
I called over the radio that I had a potential subject running westbound through the alleyway. Wasn't able to locate him as I had lost him, but I said he's possibly heading to the training center.
Okay. And where did you head next?
Since I didn't have eyes on foot, I returned to my patrol car that was parked on Washington Street.
Okay. And where did you travel next?
Officer Lundy at this time went over the radio saying that he had apprehended him at Speedy's Big Burgers right on, I think it's 15 North Arab Street. And that's where I met up with them.
Okay. And you circled around and made contact with Officer Lundy?
Yes, sir.
Okay. At the time you made contact with Officer Lundy, did they have an individual in custody?
Yes, sir.
Do you see that individual in the courtroom here today? Can you identify an article of clothing that he's wearing in court here today? And may the record reflect in court identification of the defendant?
And without objection, records also reflect.
And the individual that Officer Lundy had in custody, was that the same individual that you saw flee through the alley?
Yes, sir.
Thank you. Were you involved at all in the search of his person or anything of that nature? Thank you. People have no further questions.
Cross-examination.
Is it okay if we refer to the individual as Mr. Scott? Did you observe Mr. Scott commit any crimes that day? Fleeing and eluding? So what type of vehicle was he driving? But he was fleeing and eluding? He's fleeing it. Okay, so that would be more like an R&O. Did you see him commit any other crimes? He had possession of a firearm? And when did you see him in possession of a firearm?
And when Officer Lundy did his initial search after getting him in custody, we found a holster with an officer chief's found this card.
And when did you see this video?
The transit center provided us the picture of him when we first got to the transit center. He initially arrived on the call.
And that's the picture in your police report? And you'd agree with me, there's no firearm visible in that picture, is there? May I approach the witness with what may become defense exhibit 1?
Sure. I don't know what I'm going to do with the computer unless we're tagging the whole thing, but go ahead.
Is this the picture we're talking about?
Yes, sir.
And where's the gun?
Oh, yeah.
Not a liquor bottle?
That's not like a liquor bottle was found in his pants. That's in his waistband.
Okay, so this right here looks like a gun to you.
Yes, sir.
Your Honor,
Want that marked?
I move to admit this as defense exhibit 1.
Well, I need the photo. Well, yeah, I know. I saw it when I was up here.
Can I print it out between witnesses and provide it to the court?
Sure.
So based on that picture, you believed my client was in possession of a gun. And you say that when he was arrested, he also had liquor bottles on him? And that's admitted as defense 1?
Well, I don't have it yet, but there's not going to be an objection if that's what it is.
No, that's
All right.
photograph is.
Once I have the photograph, then I'll admit it.
I'll provide that to the court. Thank you. No further questions.
I don't.
No redirect? Thank you, sir. Sir, please come forward and be sworn.
You can take it. Don't read from it.
We take a seat right here. You solemnly swear to affirm the testimony about to give the truth, the whole truth, and nothing but the truth. So state, spell your first and last name for the record.
Thank you. Sir, how are you currently employed? How long have you worked with the Ypsilanti Police Department? Were you working back on January the 23rd of this year, 2025? And were you also involved in a dispatch to the transit center regarding a disorderly person possibly with a firearm?
Yes.
Okay, and where did you go based on that information?
He didn't advise about to get a run through towards the transit center. So I drove my patrol vehicle to Allen Street, got in my patrol vehicle, walked eastbound, and I observed semi-entree walking.
You observed, I'm sorry, what was that? In the area that you observed this person, you've identified as Savi Entree, is that individual in the courtroom here today? Can you tell me what he's wearing? Your Honor, may the record reflect in court identification of the defendant?
Without objection, record shall so reflect.
The location that you observed the defendant, was that consistent with the information that had been provided to you by Officer Plymail?
Yes.
Okay. Based on your observations of the defendant walking through the parking lot, what did you do next?
I told him to stop walking, kind of place him in handcuffs.
You placed him in handcuffs?
Yes.
Okay. And did you conduct any sort of search of the defendant's person?
Yes.
And where did that occur?
Right in the parking lot.
What, if anything, did you find?
2 open bottles of alcohol and a firearm holster.
Firearm holster? Where was the firearm holster?
It was, I believe, on his right hip.
Fair to say you didn't find an actual firearm on his person, however.
Correct.
Okay. Based on that information, are you relaying any of this to other Ypsilanti Police Department officers?
Yes.
Okay. Which officers, if you know? Okay. Can you describe, Officer Lundy, what were the conditions on this day? Snowy? Okay. And were you aware if, like, was there enough snow that, like, you're leaving footprints, or is it dusting? Can you describe it in any way?
Honestly, I don't remember.
That's fair. Did other officers make contact with you once you had the defendant in custody? Did you have any contact with Officer Cheese, or was that subsequent to this?
No, I heard him say that he found the firearm, and I just told him to take pictures of it before he picked it up.
So you heard that on the radio?
Yes.
Okay. Did you actually see where he found that firearm?
No.
I have no further questions, Judge. Thank you.
Cross-examination.
Thank you. Good morning, officer. You said you found the holster on which side of him?
I want to say it was his right side.
Okay. And was that inside the pants holster, outside the pants holster, something else?
I want to say it was like on his belt, kind of like outside-ish, but I'm not really sure. I just know it was on his person.
You were able to observe my client before making contact, right? Did you see the holster before you made contact?
No.
Was it fair to say that it was obscured by his overcoat?
Right.
And it's just like a winter coat, right?
I'm not sure what kind of coat it was. I just like a vest, possibly.
Well, all right. So you don't remember if the holster was on the right or left side? Was that not important to you?
It was clear. I think his testimony was he believes it was on the right.
Okay. And he is wearing a winter coat that covered his waistband area when you arrested him, right?
That's our coat.
Okay. Did you see any guns sticking out of his coat pockets or anything like that? You never saw my client possessing a gun, did you?
No.
Okay. What type of liquor bottles did he have in his possession?
It was like 2 tequila bottles.
A full-size fifth or a pint? All right. May I approach the witness?
May
I'm going to show you what's already been admitted as defense number 1. You recognize the person in that
defense
picture?
it's defense exhibit A.
Hey, okay. Sorry.
I recognize the outfit, not the person.
It's not the person?
It looks like he has a mask on.
So you don't recognize this person whatsoever?
Like I said, I recognize the outfit, clothing on him, but the face is kind of, I don't know, that's not a clear picture.
This stuff. Does the clothing match the person you arrested that day?
Yes.
And you point out to us where you believe the holster would have been.
Right side here.
Okay, can you put a X and put your initials? And are you able to tell what this would be on his left side pocket?
That's an alcohol bottle.
Thank you. I don't have any further questions for this witness.
No redirect.
May step down. Thank you, sir. Recall your next witness.
Officer Cheese.
Sir, please come forward and be sworn.
See, raise your right hand. Solemnly swear to affirm the testimony you're about to give, the truth, the whole truth, nothing but the truth, so help you God. Have a seat. State, spell your first and last name for the record.
James, James, Cheese, Cheese.
All right, you may inquire.
Sir, how are you currently employed? How long have you worked as a police officer with the city of Ypsilanti?
Over a year now.
Okay. Were you working back on January the 23rd of this year, 2025? And were you involved in a dispatch to the transit center on Pearl Street in the city of Ypsilanti for a report of a disorderly person, possibly with a firearm? Where did you go when you received that dispatch?
Parked my vehicle between dry cleaner on the corner there, so just across the street from the transit center.
Okay. And if anything, did you observe when you parked your vehicle? Did you observe anything when you parked your vehicle initially?
Other than my counterparts in the parking lot, I received
radio traffic from our sergeant, that he observed, the suspect running through the buildings in which my vehicle was parked.
Okay. So you were aware, based on the dispatch traffic from your other officers, that the defendant had gone through an alleyway? Is that fair to say? Based on that information, what did you do?
Going to look for a possible discarded firearm.
And is that what you actually did?
Yes, sir.
Where did you go in looking for this firearm?
Went back to my vehicle to, start looking from there. And when I came toward the parking lot and looked down to my left between I believe the address is 213 Borough and the guardrail right behind that building, I saw a white in color pistol.
A white in color pistol?
Yes.
Do you know what the make of this pistol was?
Once I was able to recover it, it was a Glock 19.
Okay, but it was painted white? Or did it come like, was it like, you don't normally see white guns, is that fair to say?
Yes, sir.
Okay. Can you describe, like, was this modified or did it just come that way?
I'm not an expert in that, so
Why did you look in this area for the gun?
like I said, from the sergeant's information, that was the direction in which he observed the suspect.
Okay. Could you describe what the weather was like on this day?
It was cloudy, but there was snow on the ground.
Okay. Was there anything in and around where you located this Glock in the snow that would indicate anyone had walked by or anything like that?
Yeah, so I did notice, because I had never walked past the firearm until I said it was pointed out which the direction that the suspect had possibly ran. But there was a fresh set of footprints, and there was only one set of footprints going through the snow area.
Okay. And was there anything that would make you believe that this Glock had been in that area for some period of time? Was there anything covering it, on top of it, anything like that?
No, sir.
And I'm trying to get the location just so the record is clear. So you come down Adams and so you're referencing the dry cleaner at the corner of Pearl and Adams. It's like Trojan Dry Cleaners. Okay. Where in relation to that did you locate the firearm?
I don't know how exactly to pinpoint it. So if we are facing in the southern direction.
Okay.
There's a big gap in between.
Yep.
The other building.
Okay.
13th row.
Yep.
Right behind, in between the vacant space area behind that building, there's a guardrail, and right behind the 213th row was the firearm between the guardrail and that building.
So immediately behind 213 Pearl is an open parking lot. Does that sound correct?
There's a guardrail and then the park.
And the area this was consistent with the information you have been provided with the path of travel of the suspect.
Yes, sir.
Okay. Where was the suspect? Were you aware that the suspect at some point had been apprehended by Officer Lundy?
I was under the impression that he was in custody.
And do you know where Officer Lundy had contact with him?
No, sir.
I have no further questions, Judge. Thank you.
All right. Good morning, officer. Can you tell us how many sets of footprints were in this area?
In which area, sir?
Sorry?
In which area?
In the area that you're describing where you found the gun.
Like I said, there's a broad area are you saying the exact right next to the firearm or in the area that I was standing?
In the area you're searching.
In the area that I was searching.
Yeah.
There were other footprints, including my own, but there were no footprints other than the one set of footprints next to the firearm.
When did it stop snowing? So you don't know if these footprints were made the day before, do you? Is that a no?
There was one set of footprints directly next to the firearm.
Right, but you don't know when those footprints were made. Is that fair to say?
I wouldn't be able to tell you that, sir.
Okay. And would you also not be able to tell us when the firearm was left there?
To say that an officer observed an individual go through the area,
Well, did you observe a person with a gun?
I did not.
Okay. I just want to talk about what you saw.
I only observed the firearm, one set of footprints in that area.
And you didn't observe anyone put the firearm there, did you? But do you understand my question?
I do not, sir.
Did you see with your own eyes that firearm placed in that location?
I did not.
Okay. And did you at any time see my client in possession of a firearm?
Are you asking?
I'm asking, did you see with your own eyes this person right here possessing a firearm?
No, sir.
Okay. No further questions.
Any redirect?
No redirect. Thank you.
All right, you may step down. Thank you, sir. And I have Exhibit A.
Defense has no witnesses.
I didn't address, I was just pointing. Exhibit.
Any other additional witnesses for the group?
The only thing that people would put on the record, I don't expect that there is an objection. That the defendant has a prior conviction for home invasion, 3rd degree out of the 22nd Circuit Court on August the 7th of 2019. He pled guilty, and with that, other than that, unless there's an objection and the defendant doesn't have that prior felony conviction.
I think they need a certified copy of that.
Okay, all right.
All right.
Okay, no, that's fine. You want a certified copy? We can, where was the conviction?
22nd Circuit Court.
So we'll have a certified copy here in minutes, counsel, if we want to play that game. That's fine with me. I don't have a problem with that. No,
We'll draw the
let's not. And while we wait, and I need you to get a copy off of, I need a certified copy of his conviction from Odyssey. We'll get it.
Can I withdraw the objection, Your Honor?
Pardon?
Can I withdraw the objection?
Well, then what? Because you realize you're wasting the time of the court?
I would say in good faith, Your Honor, that works in a lot of courts in southeastern Michigan.
Well, welcome to Washington. What do you want to do? I mean, I will get a certified copy. If it will satisfy you that there was a previous conviction, I will get the copy.
No, I will withdraw it because I know that you can do that. I'm just saying in certain courts, they have to have it here right now. And I understand that's not going to work with Your Honor. So.
Oh, it's not. It never has.
I did not know that though.
Yeah,
So
well,
I mean,
now we all
I'm
learn
not trying to.
Every day is something to learn something.
Yes,
Now you know
exactly.
that. So are you withdrawing the objection?
I am withdrawing
Do
the
you
objection.
stipulate to the conviction?
I will stipulate to the.
Wonderful. All right.
No further witnesses, the people would rest.
The only thing I'm going to ask before I ask for argument on bind over, and we don't need to do it. Where's the one that the officer drew on? You asked the officer to mark something,
Oh, yes.
and I think you were defendant's Exhibit A,
Yes.
but this doesn't appear to have a marking.
Can I approach the bench? I barely see the. I get that it's hard to see, but.
I see. All right. Okay. All right.
Thank you, Your Honor. You heard testimony from 3 separate Ypsilanti Police Department Officer Plymale, who testified first, received information about a disorderly person possibly with a gun at the transit center. He was in the vicinity of Washington and Pearl Street, observed an individual, I believe he testified heading southbound on Washington, in that area consistent with the description given to him by the transit center. And he testified that he had seen that photograph. In an attempt to stop that individual, they then fled kind of back northwest through this parking lot back in the vicinity of the transit center. Officer Lundy testified that he had subsequently apprehended defendant who identified as backup Washington. It's a little confusing, but kind of back up towards the transit center. When he arrested the defendant, Officer Lundy testified that he recovered a holster to a firearm, but no firearm on the defendant's person. And finally, you heard from Officer Cheese, who testified that in the area just south of Pearl Street, and it would be just east of Adams. So you have Pearl Street, Washington, Adams, kind of a block there. Behind, just south of Pearl Street, behind 213 Pearl Street. In there, he found a white Glock 19 that had appeared to have there was nothing to indicate that gun had been there for any prolonged period of time. But this single set of footprints in the area in the snow. Obviously, this is a circumstantial case. There's no single witness that observed the defendant in possession of the firearm. But I believe that based on the testimony of the 3 witnesses, there's sufficient evidence to a probable cause standard to establish the defendant was in possession of this firearm at the time, and prior conviction for home invasion, it would be ineligible to possess that. People would find the defendant over on the 3 counts before the court.
Response.
Your Honor, the defense objects to the bind over on all 3 counts. As to count 1, specified the gun was ever concealed. The testimony was that from the first witness was that the thing that's say a liquor bottle, as identified by the second witness, was a gun. And you can tell by looking at the picture, it's a liquor bottle, it's not a gun. And if it was a gun, it wouldn't be concealed. So the only witness to ever say anything about my client with a gun said he could see it, and that would negate the concealed element of that charge. So we'd ask the court to dismiss that. Count two, firearms possession. This is simply possession. We stipulated to the prior. Your Honor, there's no evidence that he possessed a gun. The first witness said you can see it in the picture. The defense absolutely objects to that. And the second witness agreed with the defense position. You can't see a gun because there is no gun. And then there was perhaps a bit of hearsay, but the court, of course, heard Mr. Childers say it wasn't offered for the truth of the matter, so the court should not use that for the truth of the matter, cannot be used as substantive evidence against my client. So there's absolutely no evidence that he ever possessed a firearm. Count three, no one even mentioned ammunition.
But aren't those questions of fact as to whether or not, given all of the testimony as to whether or not he possessed it?
I don't think it's a question of fact. They didn't even say it. I mean,
They didn't say what?
the testimony that he had possession of the gun was that in the picture, you can see the gun. And that witness identified what is obviously a liquor bottle.
No, go ahead.
That was the testimony from the first witness. He said, he repeated the hearsay, and it was offered not for the truth of the matter asserted.
I know, it was I had the objection.
Okay, so he ran, the evidence is they're called for a disorderly person. He runs away. He's in possession of liquor. He's running because he has open containers of liquor. They're going to say he's running for whatever other reason. They arrest a person with a holster. They don't have fingerprints. They don't have DNA. They don't have surveillance video. They don't have a witness that credibly says he had a gun. That people's first witness said you can see the gun in his pocket, and he's talking about the liquor bottle. So, Your Honor, there's simply no evidence that
The officer's state of mind based upon the call is that there's an individual, and that individual has a weapon, has a firearm, right? They find the individual as described. His path is traced. On his person, there is a holster, and upon his path being traced, there's a Glock 19. Tell me why that doesn't create issues of fact as to all three counts.
Because the call is not admissible to prove the truth of the matter. They can use that call to show the officer's actions, okay? And the officers took actions that were reasonable based on the information they received. But the people admitted that call, not for the truth of the matter asserted, but for the effect on the listener.
Take that out, right? They get this call,
Yes.
right? The truth of the matter as to whether or not he had a gun, I can't accept. But the very fact of everything that happens afterwards, doesn't that create an issue of fact as to whether or not he had the gun on his person and it was concealed?
No.
Okay.
I mean, they didn't have.
I don't know what, I don't even know how you get there, counsel. I just don't. But okay, you answered my question.
Okay, well, I'd still ask the court to dismiss count three because there is no testimony of any ammunition. And I mean, the count one, if the court is relying on this testimony, the gun wasn't concealed because they said they saw it. They said they saw the gun, which means it's not concealed. So I understand the court's position on count two.
No, you really don't. But go ahead.
Well, I meant to understand the court's position on count two, that he was in possession, but the whole way that they get to count two is people seeing it, which means there's no count one. And not a single person mentioned ammunition, which is count three.
Any response from the court in listening to all of the testimony, and granted it is indeed a circumstantial case, the testimony, and counsel seems a bit confused because I'm not taking it as substantive testimony that he had that gun. It was what the officers did afterwards. There's a clear dividing line on that. And if you do the analysis, then it's what the officers do afterwards that leads to what happens. And so when that occurs, they're investigating this person. This person is fleeing from them, or at least resisting the officer's attempt to stop him. He travels a certain path. They travel. Ultimately, they search that same path. There is a weapon found. There's a holster on him. As to whether or not it was ultimately concealed, question of fact. As to whether or not he was in possession of it, counsel, you make great arguments, but they're arguments for trial. They're not arguments for this type of proceeding. And I think that there's sufficient evidence, certainly to bind the defendant over on counts 1 and 2. I would agree with defense that there is not sufficient evidence as to the ammunition because there was no testimony. So defendant is bound over to stand trial on counts 1 and 2. As to we've got to deal with your community corrections, but before we do the circuit court arraignment, have you seen his progress report?
I have discussed it with my client, Your Honor.
And Mr. Allen?
Well, our position would be that he did have a card. It's now expired. He's in the process of renewing the card. I would also state, I think.
Well, but hold it. They asked him. Well, let's get this. Pardon?
Using prior to being placed on bond with those conditions. So we would ask the court for an opportunity for him to present a renewed card to the circuit court. Also indicate this case doesn't involve marijuana. Marijuana is now legal. So certainly the court has the discretion to impose that bond condition. But given, this isn't a marijuana.
What is his bond condition?
I believe it's no marijuana.
Thank you.
Right. So, Your Honor, we'd ask for the opportunity for him to renew his card, which he is in the process of doing.
He was supposed to take another test and he missed his test.
I looked at that and does it look like there's no date? It was unclear to me what was missed.
Did he take his last test?
It says no.
He missed it.
Can he speak on only the issue of the testing? Don't say anything about the case.
So the lady that included the correction, she told me if I didn't have the money, I didn't have the money to text her, and I said, I got the trailer of it and stuff, called her. I told her I can't make it today. I don't got the money. She like, whenever she said I called, I did one time, and I didn't have money to go to the trailer. Then she told me to stay home, and so I let her know. So that's what that was.
He doesn't have a current card.
He had a card. It's expired in 2024.
I know he had a card, but he doesn't have a correct.
Right.
They advised him that he was instructed not to use and continue any use, correct?
Your Honor, I would just indicate, I don't think those.
Want to answer my question first or no? They told him not to use in February, right? Until he got a card.
Right.
And he's not presented.
I don't dispute that. I would say, Your Honor, he asked for 30 days for his system to clear out. It's not clear that these tests indicate use while on bond. This offense date is January 23rd. So I think he's, placed on bond October 24th. I don't see any failed tests within 30 days.
They want me to get levels.
We would just ask the court to.
Really want me to get levels.
Well, I think I made my arguments, so.
So I'll take that as a no.
Correct.
Before I deal with the ultimate issue of bond on this, you waive formal reading of the complaint of the information.
Yes, and stand mute.
Defendant waives formal reading, standing mute. Counts 1 and 2. Court will enter a not guilty plea. Pretrial will be set for
April 24th at 1:30 before Judge Slay.
April 24th, 2025, 1:30 before Judge Slay. Defendant needs to follow the conditions of his bond. He's not supposed to be using. I know why you don't want that. So at this time, I'm going to revoke the defendant's bond. Defendant's remanded.
This time, we have Mr. Wilson back in court facing multiple charges. I mean, from resisting and obstructing an officer to firearm-related offenses, probation violations, and even outstanding warrants for child support. Let's see how the judge handles this.
Yes, I said that out loud. Yeah.
We'll be cautious with this, put down next.
Court does call the case of the People versus Emerson Wilson. Two cases.
Good morning. On behalf of Emerson in both matters. 1412 and 0116.
Your name, sir?
Emerson Antonio Wilson.
As to case number 24 FB 1412, the people are unable to proceed as to 1, 2, and 3. It would ask the court to remand on counts 5 and 6.
5 and 6.
And, oh, 4, 5, and 6, sorry, Your Honor. And then as to case 25F20116, it's my understanding the defendant will be pleading to adding count 2.
Yes, the plea form that I have in front of me indicates that the defendant would be pleading to attempted resisting and obstructing. And that's a no contest plea. Upon a successful plea to that charge, count 1 would be dismissed.
That's our understanding, Your Honor. I would ask that in 1412 that those matters be dismissed. Understand the court would remand.
1 and 2, 1, 2, and 3. Yes, so starting in case 1412, 1, 2, and 3 are dismissed, the people being unable to proceed. The defendant will maintain his not guilty plea to counts 4, 5, and 6, and those will be remanded back down to the 14B District Court. I will set a pretrial date on that matter for
March 17th at 9 a.m. before Judge Washington.
March 17th, 2025, 9 a.m. That is before Judge Washington.
And Your Honor, regarding bond in that case, if I could address that.
Yes, go ahead.
Just regarding that, he currently has a $25,000 cash or surety. Certainly with the 3 felonies being dismissed, I'm asking for a reduction of bond. I do understand that there is a hold out of another county. However, I'm asking for a reduction at least.
What's the hold for? What's the hold for?
There are 3 felony counts regarding firearms.
Out of what county?
Wayne County. I understand if he were to potentially be released from here, they would pick him up.
They would take him there to face those. So.
But as he's resolving those out there, certainly a lower bond here, if at some point he'd be able to post, it would towards his advantage.
Well, all of that's not going to occur in the next 2 weeks, is it?
Yeah. Well, he has to get arraigned out there.
He's not even been arraigned on those.
I don't believe he's been arraigned.
They're warrants, outstanding warrants.
Yes.
That says bond remains the same. I have 4 bench warrants for, I think, child support. Then I have the bond denied hold out of Dearborn Heights for the firearms charges. And then I also have another hold out at Canton for obstruction of police officers. And I think that is at $452 is the bond on that one. So that's that bond remain the same.
In this case, I'm going to deny the request for a bond reduction. I'll have his bond continued. Certainly get a clearer picture. Judge Washington will be more than happy to handle that. Okay. So in the other matter, he's going to no contest.
There'll be a no contest.
Base contest plea.
Lack of memory.
All right. May I have the defendant sworn?
Right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole nothing but the true self you got?
Yes, I do.
State your name.
Emerson Antonio Wilson.
Sir, it is this court's understanding that you're going to plead no contest to the charge of attempted resisting and obstructing a police officer. Is that correct?
Yes.
Now, that is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes, I do, Your Honor.
Do you understand what a no contest plea is?
Yes, I do, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing you need to understand is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, I do, Your Honor.
I also need to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, I do, Your Honor.
Understanding all of that, you still wish to plead?
Yes, I do, Your Honor.
You still wish to plead, I'm sorry.
Yes.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I do, Your Honor.
You signed an advice of rights form, is that correct?
Yes, that's
Any questions regarding any of the rights contained on that?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of it.
Yes, I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, I do, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes. Yes, Your Honor.
And of your own free will?
Yes, Your Honor.
The court has been provided and has reviewed Washington County Sheriff's Office report for their case number 256174. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt. Counsel, have I complied with the court?
Yes, Your Honor.
The court will accept the defendant's plea of no contest to count 2. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing will be
March 11th at 11 a.m. before Judge Barr.
March 11, 2025, 11 a.m. before Judge Barr. Likewise, in this matter, I will have bond continued.
Thank you, Your Honor.
Thank you.
Finally, this last case centers on Mr. Langston, who was caught illegally carrying a firearm in his vehicle. Instead of following the law, he chose to risk it all.
Hey, who's next? Thank you. Melvin Langston? Oh, there he is.
Does the court still have the exhibit?
Yes.
Oh, Your Honor, may I approach the plea form?
Oh, is that a waiver?
No, we worked out a misdemeanor plea on Mr. Langston.
Oh.
Yep.
Oh. Mr. Dox had me send it up on a felony. All right, anyway, the court does call the case of the people versus Langston.
And good morning, Your Honor, and your staff, Attorney Quentin Dox. On behalf of my client, Mr. Langston, please state your full name for the record.
Has he, just make sure we got everything here. Oh, he did execute it. The plea form before the court indicates that the defendant will be pleading to the charge of improper possession of a firearm in a motor vehicle, a 90-day offense. Upon a successful guilty plea to that charge, counts 1 and 2 would be dismissed. There's also an agreement to no objection to HIDA. That's the court's full understanding of the agreement.
Yes, Your Honor.
Yes.
Okay. All right. May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of improper possession of a firearm in a motor vehicle. Now, that's a misdemeanor. It is punishable by up to 90 days in jail, $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that, sir?
Yes.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. All right. Now, understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. All right. You signed an advice of rights form today. Is that correct? Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Right.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily? I'm sorry, I didn't hear that.
Yes.
And of your own free will. All right. Sir, on the date of January 27, 2024, at MacArthur Boulevard near Wire, Sperry Township, Washington County, State of Michigan, were you in a motor vehicle?
Say it again.
Were you in a motor vehicle?
Yes.
All right. Did you have a weapon in your possession?
Yes.
All right. Do you have authority? And it was in that vehicle?
Yes.
Where was it in the vehicle? Where was it in the vehicle?
On your possession.
My possession.
Okay. Did you have it on your person?
Yes.
Okay. And you don't have any authority to carry a weapon in that fashion in that vehicle, do you?
No.
All right. Counsel, have I complied with the court rule? Would it be proper to accept the defendant's?
Satisfied, Your Honor.
All right. Court will accept the defendant's plea 2, 3. Counsel 1 and 2 are dismissed.
Thank you, Your Honor.
Pre-sentence investigation and report is ordered at 14A2 probation.
Okay.
Sentencing in this matter will be
April 1st at 10 a.m. before the bar.
April 1st, 2025, 10 a.m.
Yes.
10 a.m. before bond will continue.
Thank you, Your Honor.